Ladies and gentlemen, hit subscribe to this channel right now. CBS News, MSN. It's all over. If you look, you can type in Supreme Court releases new orders. CBS News, Supreme Court releases new orders ahead of opinions in controversial cases. Number one, he's going to get, former and future President Donald Trump will get a huge, monumental constitutional victory on presidential immunity. I have been telling people that for months now. I told people that he would get a huge victory overturning an absurd, unconstitutional Colorado ban. I am telling you, the Supreme Court is going to do two things, and I'm going to explain this in about 3 minutes of a 1-hour live stream. You could just watch the first 3 minutes or 4 minutes, but the 1-hour live stream will go into detail. Number one, the conviction in New York was unconstitutional because it relied on an imaginary, invisible, non-existent federal statute. There is no federal statute that was leveled against Trump. They said it was an FEC crime, but the FEC did not issue any federal statute against Trump. The FEC dropped the case. It is unconstitutional. Just today, the Supreme Court released information that they're going to rule and decide on key cases. 100% he'll get partial immunity. That's why Biden and Democrats are after the Supreme Court as they pontificate about the Constitution and democracy. The Supreme Court is the rule of law, is the only thing upholding the rule of law and democracy in our republic. Number one, he's going to get a huge victory on constitutional presidential immunity over the special counsel. He'll win in November with a landslide, I believe, and he'll dissolve the special counsel. Number two, the Supreme Court will overturn the conviction. I'm telling you, it's a 100% certainty. I don't know when they'll get it. I cannot be certain about when. It is unconstitutional, and anyone who tells you that it's not should listen to Bradley Smith and Hans A. von Spakovsky and the Federal Election Commission that dropped the case. You have to be an ignorant fool not to understand that a state court cannot level a federal charge at a citizen of the United States of America without the federal government involved. A federal statute was never leveled against Trump, a specific statute. This is, I think, the vagueness doctrine, but this is a boundless definition, the same boundless definition of a crime that had the Supreme Court overturn unanimously the Bob McDonnell conviction in 2016. That's why you hit subscribe to this channel. Essentially, the Supreme Court has already ruled that the Trump conviction is unconstitutional. This is Bradley Smith. There was no federal crime. If this is the only time you're hearing this, hit subscribe. The first time, there was no federal crime. The Supreme Court, within tomorrow or the next week or couple of weeks, is going to tell you, number one, Trump is going to get a huge a partial immunity victory. Number two, they're going to overturn an unconstitutional guilty verdict. Here's Bradley Smith explaining why it's unconstitutional.
I mean, but how does that get up to the Federal Election Commission, which has already turned this case down once?
Right. Well, this raises yet another question. Can, of course, a state prosecutor prosecute an alleged, quote, federal crime that the Federal Election Commission and the Department of Justice have already decided not to prosecute? We might think about it this way. Imagine if New York just passed a law saying it is a violation of the New York Penal Code to violate any federal law. And then we'll decide what federal law is violated, right? That would subvert the entire federal state structure of law. I mean,
they have subverted the federal state, the state and federal structure of law. It is not possible for the state of New York to level a federal crime without the FEC involved. The federal government, the Department of Justice, and the Federal Election Commission dropped the hush money case. They literally fabricated a legal statute. They just said, he committed a federal crime, just trust us. A state cannot do this. You're looking at a unanimous Supreme Court decision. I think they've already decided. It's just a matter of when it gets to them.
That would allow state DAs to start prosecuting anything they think is a violation of federal law, even though the federal courts or federal administrative agencies or the Department of Justice had felt it was not a violation of federal law. So it's really getting into sort of wacky legal theories, but also I think very dangerous theories. Again, if we think about the rule of law, I don't think this can be emphasized enough that if Trump had paid for these with campaign funds, which the DA says he had to have done, I think they'd probably be chasing him today for illegal conversion of campaign funds to pay this personal expense.
We don't know that.
There was no federal crime. It is so blatantly unconstitutional. You heard it from Bradley Smith, the former Federal Election Commission chairman. The state of New York, if I'm wrong, go and find the statute. They did not level a specific statute. They said FEC crimes and leave it at that. Campaign Finance Act and leave it at that. They did not level a specific statute that he broke, and they never explained. This is a Sixth Amendment issue. They did not tell Trump what he was guilty of. The FEC fined Clinton and the DNC for purchasing the Steele dossier. They gave the Clinton and the DNC specific statutes. This is another Federal Election Commission chairman saying there was no Federal Commission statute leveled at Trump.
Hans, what was the underlying federal campaign violation? Did we ever find that out?
Well, there was nothing in the original indictment about any kind of federal campaign violation. They kept saying that the legal expenses, which is what were listed in the business records, should have been a campaign-related expense, the payment that was made to Stormy Daniels. But as Brad Smith, I know, would have testified, under the test applied by the FEC, this was not a campaign-related expense, period. There's just no question about that. So for this jury to say that, oh yeah, he violated federal campaign finance laws and that justifies the underlying verdict, that is such an egregious mistake that the Court of Appeals in New York, when they get this case, they ought to reverse this almost immediately because of this and so many other mistakes made in the case.
If there happens to be a person who thinks that Trump is guilty, and he's guilty because the state of New York decides that he's guilty, that person could possibly be very ignorant of the law that Hans A. von Spakovsky just stated, that Bradley Smith just stated. These are former FEC chairmen. Trump did not break a Federal Election Commission statute or law. The FEC dropped the case because he could have paid with his own money. It would not have been a campaign finance issue. The state of New York does not have jurisdiction. They cannot decide on whether or not this is a campaign finance issue. Now, here you have the Missouri Attorney General and Trey Trainor, the third FEC chairman, stating that Trump, number one, did not break any federal laws. Number two, the state of New York or Colorado cannot, or any state, cannot level a federal statute against Trump when the federal government, the Department of Justice, and the FEC or IRS in these cases with Trump did not level any federal crime at him.
The Manhattan DA says he will not appear on Capitol Hill today as House Republicans hold a hearing on former President Trump's New York trial. Bragg citing scheduling conflicts. He is set to testify, though, on July 12th, just one day after Trump's sentencing. Federal Election Commissioner Trey Trainor and Missouri Attorney General Andrew Bailey set to testify today at today's hearing, and they join me now. Trey, you notice I emphasized the election in your title. I guess we're finally set to hear from somebody who actually understands how election law works. Juan Merchan cannot silence you. What are the top points, Trey, you're going to try and drive home today?
Well, the most important point is that Judge Merchan completely obliterated what's been longstanding federal election law with the jury charge that he gave, asking the jury whether Donald Trump had willfully contributed to a campaign. And the legal standard has long been knowing and willful standard, so he's completely upended that standard. And it's one of those things where the Department of Justice should have intervened early in this case and protected the jurisdiction of the federal government to enforce federal campaign finance law. They didn't. They didn't protect the jurisdiction of the Federal Election Commission.
They usurped or circumvented the jurisdiction of the Federal Election Commission and the federal government. Why did they do this? Because the state of New York had to elevate misdemeanors. So there are a lot of left-leaning channels or pundits telling you, well, I don't think that, well, we spoke to this legal expert and they said that that Trump has no avenue to the Supreme Court. It is blatantly unconstitutional. There was literally no federal statute that Trump broke. We know this because the court in New York did not say that they utilized New York penal codes. They did not utilize FEC statutes. When Clinton's campaign and the Democratic National Committee were fined by the Federal Election Commission for breaking campaign finance laws after they cheated Bernie Sanders in a complete farce of a primary, they used his campaign donations and other donations to purchase a dossier from a foreign intel agent full of lies and deceit. That was an FEC violation. The hush money was not, because it would have been celebrities pay all the time hush money. It wouldn't have even been a campaign finance violation if Trump paid from his own pocketbook.
And it's completely perplexing why they didn't do that. There's long-standing Supreme Court precedent that says that they should have.
And it's just how law works. People always fight over jurisdiction. They never give that up. And in this case, it was ceded so easily. Andrew, Democrats, of course, are going to try and flip the script, calling today's hearing playing politics. And they're going to make this point, Andrew, A.G. Bailey. They merely follow the facts and the law up there in New York City. How will you cut the legs out from under that argument?
Well, they bent the law to meet the facts in a specious legal charge. There's an unseemly amount of prosecutorial misconduct. And at the end of the day, what that does is it injects both statutory and constitutional violations into the process from the charging document onto the jury deliberations. And so this is a legally errant conviction. It's not a legally valid conviction. And that emphasizes the illicit nature of the witch hunt prosecution. And it's important that the American people understand that the goal here was never to convict President Trump of a crime. It was always to remove him from the campaign trail. Now, this is a presidential candidate that has a right to speak and that we as a people have a right to access. This has done immeasurable damage to our democratic republic, and we've got to hold wrongdoers accountable.
Let's focus on this Matthew Colangelo, Alvin Bragg dichotomy here at A.G. Bailey, because the number 3 starter right now in the Yankees rotation is not waving his hand and saying, please send me to single A so I can ply my craft. What possible reason could Matthew Colangelo, the number 3 at the Department of Justice, have to leave the DOJ, go down to the Manhattan DA, if not for his desire to help the Democrats and get Trump?
Yeah, the DOJ may not have intervened to reassert the jurisdiction of the FEC. That's the appropriate legal avenue for the DOJ. But instead, what they did was deploy resources to the state of New York in the form of Matthew Colangelo.
So listen to how sinister this all is. They don't have a legal statute that they leveled against Trump, as the Missouri Attorney General states very clearly. They don't have a legal statute, a federal statute that Trump broke. So to circumvent the fact that Trump cannot be guilty of a federal crime in a state court, they then get the number 3 or top official at Biden's Department of Justice to suddenly, coincidentally, join the New York prosecutors. And then they give the appearance that, well, there's no input from Biden, but somehow it was a federal statute because a federal employee is now on the case. There's no federal statute that was, still don't know what he's guilty of in terms of a federal crime. That's a Sixth Amendment violation, by the way. There's so many constitutional issues here. The First Amendment with the absurd gag order. There's so many constitutional issues. Anyone who says there's no constitutional issues doesn't know the law.
Like you said, the former third-ranking official in Biden's Department of Justice who led the trial court prosecution against President Trump on behalf of Alvin Bragg. So he takes a pay cut to go work in state court. He's politically motivated. Those prosecutors should have been disqualified from prosecuting that case. There was no case to begin with. A subsequent prosecutor that the court could have appointed would have identified that and dismissed it before it got this far. And again, Biden is behind this whole thing. I mean, he has managed the Department of Justice that also administers grants on behalf of the Soros-backed Vera Institute to Alvin Bragg's office with the intent of dismantling the criminal justice system. So while Alvin Bragg is ignoring crime in the subways and on the city streets, he is being trained to weaponize the criminal justice system against Biden's political opponents.
Trey, quick final word to you. If we don't stop this lawfare right now in its tracks, can our century-old justice system survive?
No, it can't. And we have a big threat to the First Amendment and whether or not candidates can actually run for office in any state, because we'll have turned loose all the prosecutors across the country, whether they be state or local prosecutors, to go after individual candidates for perceived violations of campaign finance law.
Thank you for what you're about.
He said perceived violations of campaign finance law, just like the state of Colorado had the perception Trump fomented a rebellion. There was a 9-0 unanimous Supreme Court decision overturning that. They're going to overturn the they're going to overturn the guilty verdict just like they overturned the Colorado decision. It's a matter of when it gets to the Supreme Court. 100% they've already overturned a jail sentence, any jail sentence. I mean, he could get jail for like a day or two, or he can actually accept the absurd sentence, and God bless him, that would only skyrocket his poll numbers even more, but that would be a travesty of justice. He didn't commit a crime. He's not really convicted of any specific crime, a federal crime. They have him on misdemeanors. They elevated the misdemeanors to felonies. But the felonies predicated upon an imaginary federal crime that doesn't exist. This is Mark Lemon explaining how it gets to the Supreme Court very soon.
Anything Donald Trump and his lawyers would be asking the Supreme Court to do. Why? These are federal law, federal constitutional violations, federal jurisdictional violations by an acting state judge and a prosecutor, by two people. And it's ongoing. Sentencing and other issues have to be decided by the local judge, and then the appellate level, and then the level after that. This is an ongoing violation. It doesn't even matter what the final court has to say. Again, if I'm Donald Trump's lawyers, I go through that process, but you go to the Supreme Court of the United States. Now, how do we get to the Supreme Court of the United States? This is where people get bogged down. There are writs at common law. And it really doesn't matter which writ you follow. Here's a piece by former Attorney General Griffin Bell. He would later become Attorney General under Jimmy Carter. In the Southern Methodist University Law School Law Review, the federal appellate courts and all writs. And it discusses what these common law writs are. Now, it discusses it in the context of a specific statute, the All Writs Act, that was passed as part of the original Judiciary Act in 1789. Not to get into the weeds, we're smart, we can follow this. The peremptory common law writs are among the most potent weapons in the judicial arsenal. These common law writs are used. They're rare, but they're used more and more within the federal chain of courts.
If you were born before 1971,
does he say here? Well, the basis for general judicial supervision over inferior courts, inferior federal courts, through extraordinary or preemptory writs can be found in early common law. The All Writs Act is a direct descendant of the Judiciary Act of 1789, other than the Supreme Court, which is created by the Constitution.
You find the appropriate channel, or you file the writ, the appropriate writ, pertaining to jurisdiction, Sixth Amendment, First Amendment issues, the fact that we don't know the federal crime he's committed, yet he's been found guilty of committing a federal crime. We don't know the specific crime. They just say FEC crime. There are hundreds of statutes within the FEC list of statutes that it has, with the FEC handbook. You can check it out, the Federal Election Commission. There are all different types of statutes pertaining to campaign finance. By the way, 3 or 4 of which, or 5 of which, the Clinton campaign and the Democratic National Committee broke. And that's why they received a fine for the Steele dossier, complete lies and information that misinforms. But the state does not have the authority to level a federal statute against Trump. End of story. The FEC dropped the case, and Trey Trainor, Bradley Smith, and Hans A. von Spakovsky, and the Federal Election Commission itself all stated Trump did not commit a crime.
Everything else is created by Congress. All the other courts, the number of courts, how many justices are on the Supreme Court. It granted federal courts the power to issue extraordinary writs in aid of their respective jurisdictions. And while it is clear that the All Writs Act authorizes the issuance of the traditional common law writs of mandamus and prohibitions, the phrase all writs also encompasses common law certiorari, injunctions, subpoenas. Don't worry about all that. What that really means is there's many ways of characterizing this direct appeal to the Supreme Court and relaying the facts and relaying what's taken place under the law to the court. In fact, you can use multiple requests for writs. It says choosing the correct writ to obtain the desired relief is no longer necessary in the federal courts. Different writs may be sought alternatively or cumulatively. The choice is now unimportant. The subtle distinctions among the various writs have no effect on their relative usefulness as vehicles for interlocutory review. We're not seeking interlocutory review at the federal level, but in effect we are of the state court's activities. Hello, before you finish on the state side, we have some big questions that the Supreme Court needs to answer. The jurisdictional...
They're going to try and sentence Trump before the Supreme Court gets involved because they know very well the Supreme Court will overturn the case. So they are trying desperately to get him sent to jail for misdemeanors that went beyond the statute of limitations. Okay, here are the differences. Hunter had federal charges that were pretty obvious. They were not misdemeanors that were elevated to federal crimes, felonies. In New York, the record keeping was actually fine. There's no evidence anyway that Trump told Michael Cohen, even if he did under FEC law, he could have paid with his own pocket because it would have been a one-time, it would have been an expense that he would have paid with or without 2016. The Steele dossier was only purchased because of 2016. That's why Clinton and the DNC were fined by the Federal Election Commission. That's why Trump and his hush money thing was dropped by the Federal Election Commission. Big difference. But there's no comparison between Hunter and Trump. Trump had misdemeanors that weren't even, that the statute of limitations expired, and New York tried desperately to elevate the misdemeanors to a felony with an imaginary federal crime that nobody can name. The FEC dropped the case for a reason. There is no federal crime that Trump broke, a federal statute. With Hunter, it's pretty clear cut. He broke the law. And again, you have two-tier standard, but anyway, let's continue.
Prerequisite for application of the All Writs Act is simply that the writ be necessary, appropriate, in aid of the jurisdiction of the issuing court. The Supreme Court in Labai versus House Letper Company explained the power of the courts of appeals under the Act. Quote, the question of naked power has long been settled by this court. Since the Court of Appeals could, at some stage of the proceedings, entertain appeals in these cases, It is power in proper circumstances to issue writs of mandamus reaching them. This is an expression of prospective or concurrent appellate jurisdiction. The power of the courts of appeals to issue writs is not limited to cases where an appeal has already been filed. Rather, this power of review extends to all proceedings where the actions of the trial judge at some future stage of the litigation may be reviewable. That applies to the federal chain. But as I explained here, we have violations of federal law, of federal constitutional provisions by a state court. Now, does the Supreme Court, does the federal government ever get involved in state court decisions or state law decisions or state regulatory decisions? You better believe it.
The Supreme Court can overturn any state decision if it's unconstitutional. In this case, it's blatantly unconstitutional. Trump's guilty verdict was blatantly and overtly unconstitutional, even more overt and glaring than the absurd Colorado ban. Democrats make very absurd leaps of logic, and that's why they don't like the Supreme Court. It's the only place in America today that isn't influenced by a media, a public relations monstrosity that kowtows to Democrats.
There are things called express federal preemption, which is what we have here. Federal Constitution, federal due process rights, federal equal protection rights under the Constitution as applies to the states. Federal jurisdiction under the federal election law, under a federal presidential election, and I could go on and on and on. You have implied federal preemption. You have states that are obstructing federal preemption. You have all this litigation of precedential activity that's taken place before that gives the Supreme Court jurisdiction. A state cannot regulate Congress, which is what it's doing in that court when it takes over authority for determining what a federal election violation is.
A state cannot determine what a federal election violation is. Brilliantly stated by Mark Levin. A state cannot convict Trump of a federal crime in this case. Anyone who tells you that there's no constitutional issue doesn't know the law and doesn't have even a cursory knowledge of the Constitution or the way our system of government works. A state cannot level a federal charge at anyone without the federal government involved. And that's exactly what took place with this absurd conviction.
That's important. Or the Equal Protection Clause, or the Due Process Clause, or the First Amendment Free Speech Clause about a non-disclosure agreement. Federal courts, starting with the Supreme Court, have intervened in state actions before. Civil rights issues, death penalty issues, Bush versus Gore, a presidential election issue, where you have federal jurisdiction issues. And how have they used it? Well, the Supremacy Clause, they've used the Commerce Clause, they've used the Necessary and Proper Clause. When it comes to regulating federal elections, especially a presidential election, Congress has exclusive plenary power. And the Supreme Court has overall authority. When you have an extraordinary, radical, extreme, multitudinous case of violations of federal law, whether it's substantive, whether it's process, whether it's jurisdiction, this is the case. Me, as I said first out of the gate, I'd file common law writs. I'd file a writ of prohibition that restrains a body exercising public power from exceeding its powers or usurping jurisdiction, which it does not have. It seems like this. You could file a writ of mandamus, ordering a lower court, in this case the state courts, to stay their actions while the court considers. It might go with a writ of certiorari, arguing that there is a statutory basis for it. It doesn't matter. You've got to take it to the door of the Supreme Court. They will decide whether to take it or not.
The lower courts, so the Court of Appeals in New York or lower federal courts, like for example, the lower courts, federal courts below the Supreme Court upheld the absurd Colorado ban. So, and then a unanimous Supreme Court overturned all of those verdicts. That's the same thing that could happen here. The state Supreme Court, of which the judge that convicted Trump is on in New York, could just uphold the verdict. See, the Supreme Court should get involved before then because they could take forever. But this is John Yoo making a wonderful, wonderful point.
From what is a complex layer of federal authorities and decision makers when it comes to federal election campaign law, let alone seize the authority from federal courts and the Supreme Court to make these decisions, regardless of what the New York courts say up and down the chain. I mean, whatever the New York courts say up and down the chain, that is not the final decision if the federal Supreme Court.
And by the way, I believe the Supreme Court the justices have already sided with Trump on immunity and also overturned the guilty verdict. I believe the 6 of the 9, even 7 or 8 maybe, have already sided with Trump in their minds based on Supreme Court precedent. It's pretty obvious what's going to take place. The Supreme Court is going to give Trump major victories, and then Democrats are going to melt down as always. And then they're going to talk about the democracy, while at the same time spewing such venom and vitriol against the Supreme Court. Imagine how stupid you have to be. Imagine how much of an imbecile you have to be to pontificate about democracy while at the same time disparaging the United States Supreme Court.
Court decides to step in. That's the final decision for you, New York. So if I'm in California and I see that it worked in New York because we have this lumbering appellate process, but I can interfere with an election. By the time the appellate process catches up with me, so be it. They're going to time it the same way. So this can really become a cancer on the political campaign system of the highest federal official in the United States and the election there too. No,
Mark, I appreciate what you said in your opening statement because the Supreme Court has made clear, not just in one offside comment, in 3 very clear decisions, that only the federal government can enforce federal law. Only the Justice Department and the Federal Election Commission.
Only the federal government can enforce federal law. Hit subscribe to this channel. That's why you tune in. That's why I'm telling you the Supreme Court has already made its decision regarding Trump. They've already given him immunity. They've already overturned the guilty verdict. Now it's just a matter of, in my view, now it's just a matter of the timing. That's it. I don't know anything about the timing.
Can prosecute and bring suit for violations of federal election law. They're the guardians of how federal election and bring suit for violation can enforce, not just in one offside comment, in 3 very clear decisions, that only the federal government can enforce federal law. Only the Justice Department and the Federal Election Commission can prosecute and bring suit for violations of federal election law. They're the guardians of how federal election should run. And so what happened here is that the DA, approved by this judge, Judge Merchan, grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
The Supreme Court will reverse when they hear the case. I've been pretty much spot on everything I'm telling you. This is the biggest story. That's why I do segments all the time on this. This is the biggest story in America today. Listen to this again.
By this judge, Judge Merchan, grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
When we come back, John Yoo,
the Supreme Court will reverse, according to John Yoo, according to me, according to anyone who has just a basic understanding. You don't even have to be a legal scholar like John Yoo or Alan Dershowitz, or you can just look at look at the Colorado ban being overturned. A state cannot influence a federal election. This case is even more blatant. A state cannot level a federal charge. This is 6 hours ago, Supreme, without the DOJ involved or the FEC involved in this case. Supreme Court releases new orders ahead of opinions in controversial cases. This is going to be huge, ladies and gentlemen. This is going to be absolutely huge. And you look, I want to show you this again, ladies and gentlemen, just here. This is Bradley Smith, former Federal Election Commission chairman. He's going to explain exactly, again, why it's not an FEC violation. Not only is there no FEC law that he broke, Trump, but he could have literally given dollar bills to Stormy. It would have been perfectly legal.
Issues on the so-called filing of business papers, there was still no crime.
Right. I've had a bit more time. I had the commercial break to look at the indictment a bit more. And it looks like the last couple pages of the indictment do intend to say that the crime was not disclosing campaign contributions, although they never cite a specific government statute. But here's the problem here. The prosecutor's theory goes like this. Federal law says it's a campaign contribution to make an expenditure for the purpose of influencing a federal election. Those are the key words, for the purpose of influencing. And he says, well, these payments were intended to keep her quiet, which would help the campaign, so they were for the purpose of influencing the campaign. Now, first, these payments could have been made for other reasons, right? To prevent embarrassment to his family, to preserve marital harmony, all kinds of things. But none of that really matters, because the standard here for the purpose of influencing is not a subjective standard, it's an objective one. So if I go out and I want to pay for TV ads that say, you know, Donald Trump is a ding-dong daddy from Dumas Bay, because I think that's really going to help him win re-election, it doesn't matter. Legally, that will not be for the purpose of influencing an election, no matter what my own subjective purpose was, right? It's subjective. So what counts as campaign expenditures? Things like, you don't hire a campaign manager unless you're running for office. Right. You don't take out ads saying vote for me unless you're running for office. You don't hire or establish field offices unless you're running for office. But other things you do. For example, you buy clothes whether you're running for office or not. So the fact that I'm running for office and I say, I've got to look good, and I go out and I buy a $6,000 suit that I would never otherwise buy, doesn't make it a campaign expenditure. It doesn't count. Same if I say I need a $600 haircut. Or to take a more perhaps relevant example, suppose I'm a business owner and I say I'm going to run for office, and I go to my corporate lawyer and I say, there's some lawsuits against our corporation. I think they're bogus, but let's get rid of them so they don't interfere with my run. Just settle those lawsuits. You can't settle those with campaign funds. It's not a campaign expense, even though that person's subjective purpose was to influence the campaign.
By the way,
so that's a very important part of the law.
I know. I was very impressed with the $6,000 suit. That must have been a custom bespoke suit. In your op-ed piece, it was $4,000. But I know we've had an inflation problem in the last couple of weeks. But your point here, I'm just having some fun. But your point here, Brad, if I understand it, is that you buy a suit, you get a nice haircut, whatever. You're doing it directly for the campaign. Is that correct? That's the point you're making. But if you want to
the point is, yeah.
If you want to defend yourself, your honor, keep it away from your wife, that kind of thing, which, by the way, is unproven. I mean, Stormy Daniels keeps telling people she didn't have an affair. Nobody wants to listen to her, but that's perhaps grist for another segment. But if that does not qualify because it's not directly for the campaign. Is that right? Is that my correct interpretation?
It actually goes further than that. Even though you bought that suit because you were running for office, and want it to look good, it's still not a campaign expenditure. Why? Because you buy clothes. You buy clothes whether you're running for office or not, right? And so anything that people might do, even if they're not running for office, doesn't count. So people pay money. For example, they pay divorce attorneys to try to seal up their divorce records so that those don't become an embarrassment of the campaign.
Right.
Their purpose may be to influence the campaign, but it's an expenditure that somebody who wasn't running for office might also make.
The Democrats literally were the ones who got a campaign finance. They broke campaign finance laws and were fined. The reason is because the Steele dossier full of lies and deceit was only purchased to ruin Trump in 2016. It's the only reason. Hillary Clinton and the Democratic National Committee would never, in a million years, pay a foreign intelligence operative to compile lies and gossip and deceit. Not even gossip, just outright lies. In a dossier, were it not for 2016. They did so because of their campaign in 2016. Trump would have paid Stormy. Anyone would have paid Stormy. Any celebrity would have paid hush money for an affair at any time. They don't have to be running for president. So all this nonsense about, oh, did Cohen know? And Michael Cohen said this. It doesn't matter. Trump literally could have paid her with dollar bills. It wouldn't even have been a problem.
The only things that count are things that come directly out of the fact that you're campaigning. And the flip side of this is that it's actually illegal to convert your campaign funds then to personal use. So it's actually illegal to use your campaign funds to buy that suit. It's illegal to use your campaign funds to pay a lawyer to seal your divorce records because you think that will help your campaign. And this is the real problem you have here. Not only is there, I think, not a campaign finance violation, this underlying alleged violation, but it's a situation where they're going to get Trump coming or going, because I think, knowing Bragg, and you've set the political stage very well, had Trump paid for this with campaign funds, I think we can feel pretty certain that he would be being charged today with having illegally converted his campaign funds to personal use. In other words, they were going to get him coming or going. If he pays for it with campaign funds, they were going to say it was illegal personal use. If he doesn't pay this money with campaign funds, which was the reality, now they say, oh, well, he should have used campaign funds. And that's, you know, the antithesis of the rule of law, where you set up a system where no matter what course of action a person takes, they're going to be held in violation of the law.
Well, I mean, but how does that get up to the Federal Election Commission, which
This is how it's overturned. Very simple. It will be overturned 100% for this reason. I just don't know the timing.
has already turned this case down once?
Right. Well, this raises yet another question, is can, of course, a state prosecutor prosecute an alleged, quote, federal crime that the Federal Election Commission and the Department of Justice have already decided not to prosecute? We might think about it this way. Imagine if New York just passed a law saying it is a violation of the New York Penal Code to violate any federal law, and then we'll decide what federal law is violated, right? That would subvert the entire federal state structure of law. I mean, that would allow state DAs to start prosecuting anything they think is a violation of federal law, even though the federal courts or federal administrative agencies or the Department of Justice had thought it was not a violation of federal law. So it's really getting into sort of wacky legal theories, but also I think very dangerous theories. Again, if we think about the rule of law, I don't think this can be emphasized enough that if Trump had paid for these with campaign funds, which the DA says he had to have done, I think they'd probably be chasing him today for illegal conversion of campaign funds to pay this personal expense.
There you have it, ladies and gentlemen. The court's going to come out. 6 hours ago, Supreme Court releases new orders ahead of opinions in controversial cases. I believe they've already ruled in favor of Trump with immunity, and also they're going to overturn the guilty verdict. You'd have to be a true despot and authoritarian to accuse Trump of something he didn't do, which is what they've done for 7 years now. The authoritarians and despots, totalitarians, tyrants accuse others of what they're guilty of, and what they and others of what they didn't do. Trump was never an operative of the Kremlin, nor did he commit a crime, an FEC crime, and he never tried to foment a rebellion. That's why the Supreme Court unanimously overturned the Colorado ban. The Supreme Court will, I think, unanimously overturn the guilty verdict. I think they've already done that. It's just a matter of getting into the Supreme Court. You're very likely going to get a unanimous verdict overturning the guilty verdict. And they're definitely going to give him partial immunity, which is a huge, huge victory. Anyway, hit subscribe to this channel. God bless you all. We're over 250,000 subscribers because I am one of the few people in all of this platform, maybe the internet, talking about how unconstitutional the guilty verdict is and how the Supreme Court 100% is going to overturn it. I just don't know when. Hit subscribe, people. Patreon will be below if you enjoy the channel. To my super chat, thank you, Rob. Thank you so much. To my viewers around the world in Australia, Canada, New Zealand, UK, Korea, the Philippines, everywhere around the world, thank you. Nigeria, thank you so very, very, very much. God bless you all. Tell your friends about this channel. I'll be back tomorrow. Hit subscribe. This is Supreme Court month, ladies and gentlemen. This is March Madness for the Constitution. The rule of law, democracy, will be upheld by the Supreme Court backing Trump. And the true authoritarians will then, of course, spew their venom against the Supreme Court while pontificating about democracy, which is only a complete imbecile would do that. But then again, it's the modern, it's the modern democratic